press hard and we get through the fire. Got the edge and we're taking it higher. Reaching for the ages, and we got it all. We have power.
Welcome back to Made for More. I am your host, Holly J. Moore. Here we are on another special edition of Made for More, where we get just a little bit more legal. As most of you probably know by now, my day job is as a divorce lawyer in Southern California. And today I want to talk to you about patience. You've heard the saying, patience is a virtue, and it is never more virtuous and necessary and needed and desired as when you are going through the family law court system in California. If you're currently going through it or you've gone through it before, you know what I'm talking about. This process will try your patience like nothing you have ever seen before. And so I think as part of my job as a lawyer is to really just give people realistic expectations about what they're going to be experiencing in this process. And then today, in addition to giving you realistic expectations, I also want to give you some tips. When you find yourself in these delays that are just taking way too long, I want to give you some pro tips, some practical tips on what you can do while you're waiting out some various pieces of the process. So first of all, what you should know in California is COVID really changed the game. It was bad. It was always bad. The legal process in California, just so you guys have sort of a frame of reference, it is probably one of the slowest moving, least progressive, inefficient processes. Is that a word? Processes that you'll ever find. The DMV is better than the California family law legal system. So that should set the tone right away for what we're dealing with. So it's always been bad, but COVID made it way worse. So in my law firm at Moore Family Law Group, we track a lot of metrics because we want to be able to be accurate with our clients and estimating things and things like that. Prior to COVID, an average contested divorce would take around 18 to 24 months. It is now up to 36 months. And of course, you always have the outliers. We've got divorces that have been going on for 5 years, for 10 years. And then, of course, you also do have the other end of the spectrum, the much better end of the spectrum, where you can get them done quickly. But I'll tell you how to do it the most quick of any way in a little bit. So just hang in there. But so here's a couple things you need to know is when California went through COVID, we were one of the only states where the courts just literally shut down. They didn't send their workers home and tell them to keep working and processing papers and files. They didn't work remote. They did nothing of the sort. They took COVID as an opportunity to just literally take a vacation. And so, although they still allowed you to file things. So everything kept getting filed, restraining orders, divorce petitions, requests for custody and support, and they just sat there and kept piling up. So we are literally still working our way through the COVID backlog. And the court recently has actually tried to implement new systems, new calendaring processes, and all this kind of stuff to help it. To be honest, it really hasn't helped. Some counties are better than others. Orange County is getting quicker. Riverside County is insanely long. LA County, it's very weird. Sometimes it's long, sometimes it's quick. It just kind of depends. But for all intents and purposes, COVID made the delays much more severe in the California family law system. So, okay, so what does that actually mean in real life? That means that if you are facing a divorce and you are in a contested divorce where in order to be able to share your kids in some sort of agreeable manner, but you need court intervention, you need court orders to be able to do that. What that means in real life is from the time you decide you need court intervention and you file the paperwork, you're looking at probably 3 months to getting those court orders. So what that actually means is sometimes one parent will keep the kid from the other parent for 3 months. Sometimes what that means is there's all sorts of conflict during that time because you guys can't agree on how you're going to share the kids and there's no court order to fall back on. So if you find yourself in that scenario and you find yourself as the parent who is not wanting to or not being able to see the kids as much as you want, here's my pro tip. Continually reach out to the other parent in the most polite, professional, mature, reasonable way you possibly can and ask them for time with your kids. Do it in writing, text message or email. Do not call, do not send smoke signals, do not do this by, blunt force. In writing, ask the other parent to let you see your child or children. If they say no, that's okay. Try again tomorrow, try again next week. If they say no again, you just merely want to create your paper trail. Now, I know in real life this is so painful if you're not actually able to see your kids. But what I'm telling you for two reasons. One, because maybe the other parent will allow you to see the kid, and that's great. That's yay for everybody. That's good for the kids. That's good for both the parents, because you really want to try and get as much possible time with your children while the court date is pending as you possibly can. But if the other parent is not allowing it, that's a really bad strategy on their part. So if you're the other parent, don't do that. You better have a really good reason if you're not allowing that other parent to see the child, like a really good reason. I mean, life-threatening reason. If you're the parent that's not being allowed, we need to create that paper trail that you continually ask them in the most reasonable and polite manner and they denied you visitation, because ultimately that could go to a case for parental alienation. Okay, so the next thing you need to know is when you do finally get your day in court and you've been waiting and you're picturing it to be like a Perry Mason episode where you're going to show up to court, there's going to be a witness on the stand, there's a jury there, there's cross-examination, you're in trial for days. Okay, it's nothing like that. What it is you're slated for about 20 minutes, 10 to 20 minutes, because the court is going to have probably about 30 other cases on the calendar for that same day. Now, this is not a trial. This is what we call a hearing. In California, it's called a request for order hearing. You might hear the acronym RFO thrown around. But this is a hearing where essentially it's just people making oral arguments, people meaning either lawyers or people without lawyers, making oral arguments to a judge. We never have any juries in family law. It's always only the judge making the decision. Making oral arguments to the judge about, this is my side of the story and this is why you should make the orders that I'm requesting. And then the other side says, this is my side of the story. Their side of the story is wrong and you should make the orders I'm requesting. You have between 10 and 20 minutes for this hearing. If I don't explain this to clients ahead of time, they are picturing a Perry Mason scenario and an all-day thing, and that we're just going to really, have a big go at this situation. But it's not the case. 10 to 20 minutes. Keep that in mind. I'm also going to do a shameless plug for an attorney here, because an attorney will know how to effectively orally advocate in a matter of 10 minutes. You may not, because you're going to want to tell your whole story and you've got all your emotions and everything all wrapped into it, but an experienced family law attorney will know how to have the precision of a heart surgeon to get in with their scalpel, scoop out what they really need to, and get out. And that's what you want. Okay, so here's the next thing I want to talk about is money stuff, delayed support rulings. So if you are the person that is expecting financial support, please understand that it is going to be about 3 months from the time that you file that set of paperwork requesting support until the judge makes an order. So what does that mean for you in real life? That means for you in real life, if you have no other financial means, if you have no resources, if you don't work yourself and you're worried about the other party cutting off financial support, very common. This is very common, by the way. If you're supported by the other party, they can very easily just say, zoop, nope, I'm not putting my paycheck in that joint bank account anymore. And that is their right to do, by the way. I don't want to get too far into the weeds. There is such a thing as financial abuse, but let's just keep it simple for today. They are entitled to start diverting their paycheck to a separate account. So if you think it's possible that you're going to serve the other party with papers to get child support or spousal support or both, and because of that, they're going to get mad and they're going to cut off your financial support, you need to be ready to have someone else help you for 6 to 12 weeks until, with a restraining order, it's about 6 weeks if you're doing that. If it's just a regular support order request, it's going to be about 12 weeks. You've got to figure out a way to fill that gap. Now, what you need to know is if you are the payor, you're thinking, great, I get 3 free months of not having to pay that support until the judge makes an order. But what you need to be aware of is once the order is made, it's most likely going to be retroactive to the date of filing. So that is what we call arrears. You will already have support arrears on the first day that the judge makes the support order. You can mitigate, and arrears come with interest. So the best way to mitigate arrears is as soon as you get that filing, and you're put on notice that you are being requested to pay support, you can pay the other person money. You can do it voluntarily. If you overpay, I wouldn't recommend overpaying because it's hard to get that money back. But if you overpay, there is a legal mechanism to get the money back. If you underpay, you'll have to make up for the difference. But paying a little bit of money also looks really good to the court, and it can mitigate any arrears that you might have when the judge makes the order. I wasn't really planning to do so many shameless plugs for lawyers, but I guess it just goes to the value of them. But if you have a lawyer, your lawyer will be able to run the numbers, and they'll tell you exactly how much to pay so that you're right on the nose. You're not overpaying, you're not underpaying by too much, and you're in the perfect sweet spot. Okay, so last thing I want to talk about is everybody thinks, well, Holly, who cares about all these delay orders? I'm just going to file emergency requests all day long, every day, because the fact that we don't have a court order and the fact that I'm really worried about my kids, like, I'll just file an emergency order, right? We call those ex partes. Wrong. It's very hard. The threshold for an emergency court hearing is very high, very high. Even sometimes when I'm like, this is definitely meeting the statute, the code section, the law of an emergency, the judge is like, nah, I don't think so. I had a case one time where a kid was living in a car, and we filed an emergency hearing. Mother was homeless. We filed an emergency request because we didn't want the kid living in a car. It was during winter, and they were like up in the San Bernardino mountains. It was very cold. And the judge said, no, the kid has a roof over their head, albeit it's a 1996 Honda Civic roof, but it's still a roof, and denied our emergency hearing. So I tell you that story just so you know how high the bar is for these emergency orders. And I know this is really frustrating to clients all the time because they think this is definitely an emergency, and it very rarely meets the threshold that the court requires to deal with something on an urgent basis. So that being said, as you can see, your best bet is to try and avoid court at all costs. Now, how do you do that if you're getting a divorce? Well, the more agreeable you are, the more that other remedies may be available to you that don't require court intervention. These are things like complete mediation. We do mediation at my law firm, and that's where the parties both come in. Neither party has an attorney. They both come in, they sit down, they hash out the issues, and 9 times out of 10, they leave with a full agreement. And you don't have to wait for any court processes at all. You don't have to wait for the judge to make an order. You don't have any of that waiting times to even get into court. You just sort of take your fate into your own hands by doing mediation. The other option is for some of these sort of, like if you're not resolving the entire case, but maybe you want to resolve child custody, you want to resolve support, you always have the option to enter into an agreement. And again, a good attorney can facilitate an agreement. I know some of you are thinking, not with my spouse, they can't, they're difficult. And you're right, you could be right. Like some people are just so difficult, they need the judge to literally shove orders down their throat. But if you're with one of those types of people, you just need to have the expectation that you are going to be experiencing a lot of delays and your patience is going to be tested, probably more so than at any other time in your life. But here's the good news. I don't want to be all doomsday. No one has ever died from these wait times in court. They have felt like it. Believe me, I get calls every day from clients literally saying, like, I might die if I have to wait one more day. No one has ever died from waiting. You will get through it. You will be stronger for it. And hopefully nothing else in your life will test your patience quite as much as this process. But if it does, you'll be ready for it. I'll see you on the next one. A prenuptial agreement, or sometimes called a premarital agreement, is an agreement that two parties enter into before they get married that basically chooses to deviate from state law. It assigns rights and responsibilities regarding assets and debts that are acquired during the marriage. Some common misconceptions about prenups are, one, that they basically doom the marriage to failure, or that it's really planning to divorce, and neither of those things are true. But the real value of a prenup is talking about and creating rules around how the things that you acquire during the marriage are going to be characterized. A prenup can protect things like art collections, real estate portfolios, businesses, all those types of assets. The ideal timeline to get a prenup is not 2 weeks before the wedding. The final version of a prenup has to be presented to the parties 7 days before they actually sign it. So there's like a 7-day waiting period. As soon as you get engaged, you should seek a lawyer's advice and counsel on a prenup and start the process then, because the closer the prenup is signed to the wedding, the more likely that the court is going to think there was some sort of duress involved in that person signing it, and they have to prove that the prenup was signed voluntarily in order for them to be enforced. At Moore Family Law Group, we represent a lot of high-profile people, celebrities, professional athletes, business tycoons. If you already have a lot of assets, or you think you're going to be acquiring a lot of assets during your marriage, we are the best ones to protect that for you and help you make your marriage stronger. Call Moore Family Law Group today.